Chapter 11. Damages. Section 499. When damages are recoverable, there must be loss legitimately resulting from the unlawful usurpation of a trademark, or the plaintiff cannot recover, for if there be no loss, the injury must go unredressed. It is not sufficient that an act unauthorized by law has been committed, because for injury assigned damo there is no compensation. Substantial loss to the plaintiff must have ensued by the malappropriation of the mark, the right to the exclusive use of which was in the plaintiff, to entitle him to substantial relief. De minimis non curat lex. Section 500. Thus, it would not be sufficient for the plaintiff to prove that the defendant had threatened to adopt his mark, or that he had actually, through an error as to the scope of the copyright law, filed it with the Librarian of Congress, or, through another blunder, had applied for a patent for the design, for these acts could not have worked to the legal injury of the plaintiff. There being no property in the mere representation of the symbol constituting a trademark, as has been before stated and proved, no legal harm could have resulted from a mere imitation of the symbol. The wrong consists in affixing the mark to merchandise which the public purchase, thereby erroneously supposing that it is the product of the plaintiff. That is the whole basis of a right to damages in such case. Section 501. Damages will be presumed in some cases, as where one intentionally uses or closely imitates another's trademark on merchandise or manufactures. The law presumes it to have been done for the fraudulent purpose of inducing the public, or those dealing in the article, to believe that the goods were those made or sold by the latter, and of supplanting him in the goodwill of his trade. In such a case at law, nominal damages will be given, although no specific injury shall have been proven. Section 502. No fixed and certain rule for damages can be established, applicable to all cases. 3. No inflexible or unyielding guide, but the rule generally recognized as the true one is to give as damages the amount of profits the defendant shall have made by his infringement. As in trials at law, the jury are the proper judges of damages where there is no certain measure of damages. The court ordinarily will not disturb their verdict, unless on grounds of prejudice, passion, or corruption in the jury. In all actions on the case, the question is, what is the amount of damages sustained? And that is within the especial province of the jury to answer, after weighing all the testimony. But, as a general principle, a party is entitled to damages corresponding with the amount of injury suffered, however small. Section 503. Compensatory damages should be given. The criterion is indemnity, and in estimating the actual damage, the rule is to give the value of the use of the thing during the illegal user, or, in other words, the amount of profits. As was said in analogous cases of patented machines. The proper measure of damages, in case of violation of a trademark, is generally the profit realized upon the sales of goods to which the spurious marks were attached. The actual damages for the infringement would seem, as a general rule, to be all that could be reasonably claimed. There may be exceptions. Cases may arise where the circumstances are aggravated, and such as to repel altogether the bona fides of the infringement. Each case must necessarily depend upon its own circumstances. Thus, where in an action on the case for imitating and using the trademark of the plaintiff's, on thread made by the defendant, and selling the same as and for the plaintiff's thread, a verdict was found for the plaintiffs for $800, and on a motion for a new trial, the court refused to disturb the verdict. Woodbury Jay, who had not tried the case, said that he had little doubt that there was material enough in the case from which to estimate actual damages, such as the probable extent of sales by the defendant under the marks, and the loss of sales and profits thereon to the plaintiffs, and that the jury would, in a case like that, of a known and deliberate intention, often renewed, and very prejudicial to the plaintiffs, not be very nice in their data and inferences, but be sure to give enough to cover all losses, and ample indemnity, not smart money, or vindictive damages, but full atonement for the wrong done. He said, further, that in a case like that, if in any, no reason exists for giving greater damages than have actually been sustained, or what have been called compensatory, and that there was nothing peculiarly atrocious in the conduct of the defendant to be punished by damages, and in no other way. As a public example, it seems that Judge Sprague, who tried the case, in his charge to the jury, used the term exemplary damages, but that language was construed by the superior judge to mean a full indemnity for the individual wrong, in every equitable view, that by example might operate the more effectually in a preventive manner against a repetition of such injuries. He further expressed his opinion that the jury did not give more than was sufficient to make the plaintiffs whole, but rather less than the amount. Section 504. How measured? Every trespass on property gives a right, at least, to nominal damages. All damages must be the result of the injury complained of, to wit, the simulation of the trademark of the plaintiff. Those which necessarily result, termed general damages, being shown under the addendum, for the defendant must be presumed to be aware of the necessary consequences of his conduct, and therefore cannot be taken by surprise in the proof of them. Where the damages, though the natural consequences of the act complained of, are not the necessary result of it, they are termed special damages, and are not implied by the law. Therefore, in order to prevent a surprise upon the defendant, they must be particularly specified in the declaration, or the plaintiff will not be permitted to give evidence of them. But where the special damage is properly alleged, and is the natural consequence of the wrongful act, the jury may infer it from the principal fact. Section 505. But the damages must be proved from the evidence, not from mere conjecture, independent of the evidence. A mere possible injury furnishes no ground of damages. In a recent English case, where a bill in equity had been filed to restrain the infringement of a trademark, the court offered a decree for an account of profits, but the plaintiff selected an inquiry as to damages. It was held that the law would not presume that the plaintiffs would have sold the amount of goods sold by the defendant, but the burden of proof was on the plaintiffs to show special damage by loss of custom, or otherwise. The remarks of the court have an important bearing on the subject of remote or contingent damages. How can the court assume that the persons who bought what the plaintiffs aver were inferior articles, at an inferior price, would necessarily, if they had not done so, have bought the superior articles at the higher prices? In a case where there was evidence that persons were, by false statements of the defendant's agent, induced to leave the plaintiff's coach, and to go in that of the defendants, that was held to be a fraud on the plaintiffs, and a violation of their rights, for which an action would lie, without proof of actual or specific damages, and that the damages should not be confined to the loss of such passengers as the plaintiffs could prove had actually been diverted from their coaches to those of the defendants, but that the jury would be justified in making such inquiries as to the loss of passengers and injury sustained by the plaintiffs as they might think were warranted by the whole evidence in the case. When it was stated in the declaration, and proven on trial, that the defendants had obtained some of the plaintiffs' wrappers, and used them to palm off inferior articles, metallic hones for sharpening razors, and c. as the manufacture of the plaintiff, Denman, C. J., stated to the jury that even if the defendant's hones were not inferior, the plaintiff was entitled to some damages, inasmuch as his right had been invaded by the fraudulent acts of the defendants. The jury, having found for the plaintiff, with 1 farthing damages, stating that they thought the defendant's hones were not inferior to the plaintiff's, it was held, in bank, that the act of the defendants being a fraud upon the plaintiff, even if it occasioned him no specific damage, it was still, to a certain extent, an injury to his right. This case makes it clear and conclusive that a plaintiff may recover without proof of special damage. Section 506. Election of remedies. He whose rights are infringed has his election of remedies. He may proceed in equity for the profits the defendant has made, or he may sue at law for the loss he has suffered. Section 507. In the first case, if the defendant has realized no profit, there can be no recovery. In the second, he may recover the damage he has sustained, whether the defendant has made any profit or not. He may treat the infringer who illegally appropriates an invention to his own use, making profit thereby, as his trustee in respect of such profits, and compel him to account therefor in equity. In such case, the plaintiff may recover those profits, be they more or less, and he can recover no more, however great the damages may be which the alleged interferer has occasioned. If, on an accounting, it should appear that the defendant used the invention so unskillfully that he realized no profit, there could be no recovery. On the other hand, the patentee may sue at law for the damages which he has sustained, and those damages he is entitled to recover, whether the defendant has made any profits or not. Section 508. Intent. A wrongful or malicious intent, express or implied, is an essential and prominent element in determining the amount of damages to be awarded. The general rule is that it is of no consequence whether the defendant intended the injury or not. In civil actions, the law does not so much regard the intent of the actor as the loss or damage of the party suffering. Yet in actions for the invasion of patent rights, the intent is generally considered, as in a case where the maker of a machine appears in truth to be ignorant of the existence of the patent and does not intend any infringement, and though this will not altogether exonerate him, it will tend to mitigate the damages. Section 509. Special damages. The right to recover special damages, that is, damages additional to the amount of direct and immediate injury, often depends upon the allegations in the writ. Such damages must be specially alleged, solely for the purpose of giving the defendant notice of the plaintiff's demand with regard to them, while, as before said, he is held to take notice of such damage as is the necessary consequence of his act, without any special allegation, and without any statement of the particular circumstance of aggravation. It is rarely in actions for the violations of trademarks that the right to such damages can be fairly established. Section 510. Plaintiff's negligence. In assessing damages, the direct and immediate consequences of the injurious act are to be regarded, and not remote, speculative, and contingent consequences, which the party injured might easily have avoided by his own act. Suppose a man should enter his neighbor's field unlawfully, and leave the gate open. If, before the owner know it, cattle enter and destroy the crop, the trespasser is responsible. But if the owner see the gate open and pass it frequently, and willfully or obstinately, or through gross negligence, leave it open all summer, and cattle get in, it is due to his own folly. So, if one throw a stone and break a window, the cost of repairing the window is the ordinary measure of damages. But if the owner suffer the window to remain unrepaired a great length of time after notice of the fact, and his furniture or pictures, or other valuable articles, sustain damage, or the rain beat in and rot the windows, the damage would be too remote. Section 511. We may apply the doctrine thus laid down by the eminent jurist to the case of one who stands by, and calmly sees another pirate his mark. He may sustain many injuries that by prompt action he might have avoided. Legal relief, at best, is but part indemnity. The law in fact aims not so much at satisfaction as at a division of the loss. Section 512. After a review of the few cases bearing directly upon the question under discussion, that is, the true principle for the measuring of damages in trademark infringements, we relapse into uncertainty, and despair of finding any nicely adjusted scheme to solve the problem. The infringement of a mark at one time may be destructive of the trade of the true proprietor, and at another time, and under similar circumstances, it may be comparatively harmless. An article of trade may have an ephemeral popularity which is an immediate fortune to its producer, or it may be a thing of limited sale, yet of continuing demand. All the surrounding facts must therefore be weighed by the jury, or referee, as the case may be, and although of as little account singly as the dust in the balance, yet in the aggregate they may cause the scale to kick the beam. Look at such a case as Gillett v. Estabrook, and the power of the grouping of seemingly insignificant minutiae, to make a convincing proof of fraudulent intent, will be plainly perceptible. Section 513. In many classes of cases of injury to property, the estimate of damage can easily be made, either by the value of an article destroyed or wrongfully converted, or by a previous liquidation. Thus for the infringement of a copyright, the legislature has laid down certain rules to meet all cases, but when we turn to infringements of patent rights, and attempt to reason from analogy, we find great difficulty. In Canova v. Rapp, Ingersoll, J., said that the plaintiff is entitled to such actual damages as he has sustained, and that the actual damages are the profits which the defendant has made. This was a case of infringement of a patent for a machine for splitting wood, and evidence having been given that the defendant used the machine, and also of the amount of wood split by him during each day, the plaintiff calculated from that what the actual damages were. The court instructed the jury that a plaintiff is notable, with the utmost accuracy, in cases of that kind, to give the exact amount of damages that he has sustained. It is beyond his power. He does the best he can. If he is wrong in his calculation, the defendant can put him right. The defendant knows the profit he has made. Therefore, said he, the jury must take the evidence as it is, and come to the best conclusion they can as to what are the actual damages. The jury having found a verdict for the plaintiff, the defendant moved for a new trial before Mr. Justice Nelson. He delivered the opinion that there was no error in the charge of the judge, and denied the motion. Sawyer, Jay, said, in Carter v. Baker, that the profits made by the defendants are proper to be given as a part of the damages, and that the jury might take into consideration other losses caused by the infringement, beyond those profits actually received by the defendants. In a late patent case, Cowing v. Rumsey et al., Woodruff, Jay, laid down the rule somewhat more specifically, the true rule being what the plaintiff has lost, and not what the defendant has gained. He said that, in such an action, it is precisely what is lost to the plaintiff, and not what the defendant has gained, which is the legal measure of the damages to be awarded. Under this rule it may often be entirely proper to prove the profits of the ordinary use of the invention, and the demand existing in the market, evidenced by sales made, and so, as an element of consideration, show the profits realized by the defendant, in order to furnish to the jury all proper materials for determining how much the plaintiff has lost. But I apprehend that they are to answer the precise question, how much loss has the plaintiff sustained by reason of the defendant's infringement? There may be cases so peculiar that there are no means of proving the plaintiff's loss without proving the defendant's profits, and such proof becomes clearly admissible, but, even then, the recovery is what the jury shall find to be the plaintiff's loss, not because the defendant realized profits, but because, under all the circumstances, the jury infer, as a fact, but for the interference, the plaintiff would have realized those profits. It may be said, with some plausibility, that the plaintiff's damages may sometimes be greater than the profits which the defendants have made, but ought never to be considered less, and that the defendants having illegally infringed, should always be held to the presumption that the plaintiff would have made as much as they have realized, and should not be permitted to retain any of the fruits of their illegal conduct, by showing that the plaintiff could not have manufactured or used the invention so profitably. This reasoning is lucid and satisfactory, so far as applicable to a patent case, but should not be strictly applied to a trademark infringement. Section 514. A patentee is presumed to have employed genius, or talent, at least, and to have expended time and money upon his invention, and in consideration thereof he is allowed, for a limited time, a monopoly of the thing invented. No one else in the country which grants the patent has a right to vend or use the article. All profits from its sale or use belong to the patentee or his assigns. The trade in it is absolutely his during the lifetime of the patent. Not so the traffic in merchandise to which a trademark may be attached, for 1,000 persons may have a perfect right to manufacture and sell the same class of goods, and of the same quality and value, and yet but one person have a right to impress those goods with a certain peculiar symbol. It may be that the infringer has facilities for selling 100 times as much as he whose mark is imitated. Would the small dealer be entitled to receive as damages 100 times as much profit as he could possibly have made? Reason forbids it. Courts would regard such a rule in a trademark case as extravagant and mischievous. Section 515. Trademark and patent cases, therefore, cannot be controlled by the same inflexible rule of measurement of damages for infringement. We are unembarrassed in a patent case where the patentee has adopted a patent fee as one mode of remuneration, and in the fee has fixed his own measure of the value of the use of the machine for the entire term, or until that particular machine is worn out, and the computation is readily made. For if the patentee has an established price in the market for his patent right, or what is called a patent fee, that sum with the interest constitutes the measure of damages. In one case, the plaintiff insisted that he was entitled to recover for the infringement the full amount which he would himself have made on the articles sold, had he manufactured and sold them himself, upon his own established terms. He gave evidence showing the price at which he sold, and the profits realized upon sales at those prices, and the court adopted those profits as the measure of damages. and gave him the benefit of the rule, so far as the damages could be ascertained from the testimony. But notwithstanding this will not be applicable to all cases of trademark infringements, we can understand perfectly well how the analogy may be of assistance. Let us take an example. Section 516. The plaintiff has the exclusive right to vend by a fanciful designation a certain article, the secret of the manufacture of which he possesses. It is well settled as matter of law, that he has no exclusive right of property in the compound itself, it not being patented. Consequently, if anyone by fair means discover the secret of manufacture, he may go into competition with the inventor himself, in obtaining the patronage of the public in the sales of the very article. But we set out with the fact that the plaintiff has the exclusive title in the name of the article, the said name being an arbitrary symbol, and possessing all the essentials of a lawful trademark. The public know the article by that name, and would not buy it under any other. If the defendant sell the identical compound, a knowledge of the ingredients of which he may have obtained by chemical analysis, he may do so without hindrance, provided he do not sell it under the name given to it by the plaintiff. But if he do so sell it, he is guilty of infringement of the mark. The number of articles sold by the defendant being ascertained, we have a means of measuring the damages. By applying the rule in patent cases, the presumption must be that the plaintiff would have made all the sales, had it not been for the alleged conduct of the defendant. Section 517. The courts of equity seem to indicate a rule for measuring damages, by their practice of ordering the defendant to keep an account of sales of merchandise bearing the simulated mark, to the end that they may be paid as indemnity to the complainant. But that this is an exceedingly fallacious guide in actions at law must be manifest, for many circumstances may conspire to cause injury from the improper use of the mark, and many of such circumstances must be taken into consideration, in assessing damages. Unfair competition may cause a loss of reputation and goodwill, and depreciation of the class of goods sold by the parties. Sawyer, J., in Carter v. Baker, told the jury that they might take into consideration that fact that the plaintiffs, by the infringement, may have sold their articles at a higher price than the defendants had received, and yet, he said, that only those damages which directly and immediately flow from the wrongful act can be considered, and that remote consequential damages must be discarded. Section 518. No wrongdoer can be allowed to apportion or qualify his own wrong. As a loss has actually happened whilst his wrongful act was in operation and force, and which is attributable to his wrongful act, he cannot set up as an answer to the action the bare possibility of a loss, if his wrongful act had not been done. The disposition of the courts, in such case, is to make the wrongdoer liable for injurious consequences flowing from the illegal acts, although they be very remote. Section 519. Exemplary damages. In the case of Davy Woodworth, in the Supreme Court of the United States, Mr. Justice Grier, in delivering the opinion of the court, said, "It is a well-established principle of the common law that in actions of trespass, and all actions in the case for tort, a jury may inflict what are called exemplary, punitory, or vindictive damages upon a defendant, having in view the enormity of his offense, rather than the measure of compensation to the plaintiff." By the common, as well as by statute law, men are often punished for aggravated conduct or lawless acts by means of a civil action, and the damages inflicted by way of penalty or punishment given to the party injured. And the damages assessed in the circumstances, showing the degree of moral turpitude or atrocity of defendant's conduct, may properly be termed exemplary or vindictive, rather than compensatory. Section 520. Thus, one who shall counterfeit, a term implying deliberation and intent, as contradistinguished from a casual imitation, will be held to a more grave responsibility than another who unwittingly may have copied a rival's mark.